to it. First of all, I want to thank colleague Mike Bonin for being here as well, and thank all of you. We've got a number of speaker cards, but I think what we're going to do first is we have a proposal with some draft notes, briefings on where we're at in terms of the city planning report as it relates to the residential care community facilities, as well as, and this is broken down into various sections, state licensed residential, separating the regulation of families from boarding and rooming homes, some proposed definitions, residential high occupancy permit, and we'll get into that as well, and then some of the key issues. Again, the purpose of this, as I've stated in all the meetings from the beginning, is to be as inclusive as possible, is to ensure fair equality across the board, to provide as much opportunity and housing opportunities to meet the demands of everyone throughout Los Angeles, while protecting those in those facilities as well as the ability to have some enforcement in terms of the ones that have either nuisance or serious issues, and that's been always the difficulty. So we want to ensure that that we keep that in mind. With that, I'd like to ask the planning department to come up, and we'll hear and go through all of that and reserve public comment on this item until after we've gone through the report. And I also want to thank the planning department for all of their extensive work and outreach they've done on this. It's been a number of years prior to the ad hoc being established that they've gone out, in fact, probably more so on this than almost any other single issue, where they've gone out to the community in dozens and dozens of community meetings, stakeholder meetings, roundtable discussions, working with all the different key stakeholders, city agencies. Also want to thank all the other city departments that are here. We'll hear from the fire department as well, and hopefully housing if they want to care to testify as well. So good morning. Thank you. And I'd like to also thank Councilmember Felipe Fuentes for being here as well.
And Mr. Price.
And Mr. Price. Yes. And we have a quorum. So, yes, thank you. I did see you walk in.
Good morning, members of the committee, Allen Bell Planning Department staff. What we have had in previous meetings of the committee were discussion papers, analyses of the background, and what we have before you today is a recommendation report. We drafted this report in response to the direction at the last committee to provide some more formal recommendations and actual draft changes to the ordinance that was considered by the City Council on January 3rd, 2013. So attached to your report is a strikeout underlined version of the ordinance drafted by the City Attorney, and that was considered by the Council about a year and a half ago. And that shows the changes that we're recommending, so you can see precisely what is changing and then what is staying the same. Again, we believe we're taking a balanced approach to this issue, coming up with clear definitions, avoiding the overlap that we currently have in terms of our definitions is a key to enforcement. And then we have also presented to you some intriguing new options and ideas for consideration. So with that, I'll turn it over to Matt Glesney, who is our housing planner, to go through the details.
Morning, council members. Matt Glesney, City Planning Department. I will just be walking you through the report briefly. It is sort of broken up into three sections. They're sort of all related to this larger concept of group housing, but take on different aspects of that. The first part deals with the licensed, state-licensed community care facilities for that are residential in nature for adults and the elderly. This is very simply just to allow, as state law requires, to permit a licensed facility with 6 or fewer people within all residential zones where any other family would be permitted. So that's existing state law. We don't have that in the books in our zoning code. We're already following that. But this would make it clear that you are essentially a family if you're a licensed facility with fewer than 6 people.
And this has been a state law since when?
1973, the Community Care Facilities Act. So, again, we've been following it, just never codified, and we want to make that absolutely clear that the city's following that policy. So for 7 or more facilities with 7 or more residents, state licensed facilities, the state does allow cities more discretion to develop land use regulations as they see appropriate. Currently, without any language in our code, these facilities have been subjected to a de facto variance process, which is a high-level process, requires significant findings on neighborhood impacts and such. Our thought was to try to make a more streamlined approach for licensed facilities that would look at what have been the most common issues when we've issued variances for these. They've been around noise and parking, security, lights, et cetera. And basically just put those straight into a ministerial process, a sort of checklist where an owner who wanted to convert one of these or build one of these would come in and say, okay, do you meet these sort of commonly identified markers for neighborhood compatibility? And those are listed in the report. It's basically 5. We did make one change from the previous. This whole proposal, this part 1, is largely unchanged from initially went in front of council. We are recommending one change, having the opportunity to give a deeper dive. We realized that the state already enforces a density requirement on 2 persons per room for state license. That's in the state code. We had a duplicative performance standard number 6 that basically restated the exact same thing. We just found that unnecessary, and so went ahead and removed that, recognizing that state already verifies that. So that's essentially the part 1 piece. This has been the least controversial. I don't know if we want to break and have any discussion on this or move right to the second piece.
I think we just go right to the second piece and then...
Sure. So the second piece is dealing with non-licensed group housing and how the city basically treats and deals with shared housing, group housing arrangements outside of any license procedure. So we have all kinds of these in Los Angeles. And the issue sort of arose, I think, it's been around for a while. A lot of cities do deal with this issue of how exactly, and then there's a lot of state fair housing law and court decisions on the matter. It really arose in 2006. We changed our definition of family from one that was sort of out of compliance with fair housing law to one that we believe is very much on the liberal end of definitions of family. And the definition of family is important. It basically allows... It says who is allowed to occupy a one-family unit, a single-family unit. So our definition of family is current, as written in 2006. It just says that all you need to do is any group is allowed to be a family if you share a common living area or a kitchen. So you can have essentially a group of bedrooms, and as long as those folks share a common space in the middle, they are considered a family. They currently have the right to occupy any single-family dwelling. And we found that to be very unusual in the state and nationwide. We couldn't find any cities that have a definition that allows a family to be formed without needing to be any relationships amongst one another. The only sort of marker or characteristic they have to have is having this ability to share a common area. And we found that creates confusion and potential overlap with other definitions, such as boarding and rooming house, which is typically a group of rooms where you're sharing a common space. That's a typical boarding house arrangement. You're sharing a shared kitchen, but you're renting out rooms. And so there's been difficulty in enforcing that. It's also led to situations where essentially multiple families are living in a single-family residence, and create confusion for tenants, enforcement agencies, landlords of what is actually permitted in a one-family dwelling unit. And again, we did an exhaustive survey of other cities and found that this is very much on the sort of wide open and more inclusive, I would say, but it does create these questions of what exactly is a family. And so we took a hard look at this. This has been the most controversial aspect. We took a hard look at our definition that was originally proposed to City Council, and actually went ahead and removed what had been the most controversial, the most cited aspect of that change to the definition of family. It actually, technically what we're doing is creating a new definition called single housekeeping unit, which essentially takes the place of a definition of family. So the definition of family would refer back to the single housekeeping unit. We removed what had been the lightning rod sort of clause in that definition, which was about that the landlord cannot decide who is a single housekeeping unit. That had drawn the most criticism, raised some interesting questions. We decided that can go. That was not found in many other cities. We only found Newport Beach had that, and they are embroiled in litigation. And so we are coming to you today with a definition of single housekeeping unit that we feel is squarely in the mainstream of California cities. We believe it meets fair housing law. It's a lot of it is straight from the major court decision on this topic. It's Adamson versus City of Santa Barbara. A lot of the text of what we're proposing in terms of needing to share, to now have the essential difference is now the single housekeeping unit, you would have to have some functional interactive relationship. And so there's kind of two new phrases that we're adding in to that definition. You would have to be interactive and non-transient. So some kind of interactive relationship. And then there would be an expectation that a single housekeeping unit would share activities, share responsibilities, and we list that as meals, chores, expenses, and maintenance. And so those really are the two new things that are added into this definition. And again, we feel those are found in many, if not most, of the definitions that we looked at. And that kind of language is actually straight from the Adamson court decision that said these are typical markers. This is what differentiates a family, a true sort of functional equivalent of a family, versus a group of people who don't have any relationship amongst one another. So it essentially brings the idea of there needing to be an interactive, cooperative relationship amongst housemates to call yourself truly that you are a family instead of being a group of people who don't relate, don't talk, don't share anything, just go about their business. This would say that there has to be some functional relationship amongst the residents.
Okay. Let's go through, and before we move on, because I think we need to talk about and get through the report as well, particularly in residential high occupancy permits and going through the rest of the dwelling unit and boarding room homes. And those are critically important. But I want to remind everyone that one of the reasons that this ad hoc meeting was set up in the first place was to come up with a streamlined process that's affordable and easy to get some type of permit that's not cost prohibitive, that doesn't put you through a variance or CUP process, that comes up with a new streamlined approach and the definitions for all of these things that are critically important and go hand in hand. With that, definitions were what tied this up and has been tying it up for 10 years. It's also the issue of enforcement that we've talked about and spent a lot of time on, the fact that we've gone back and forth and discussed the issue of enforcement. Building and Safety has come up and testified, not only to this committee, but has been involved in this for a decade in talking about publicly and sharing the concerns, and the city attorney's office on why the enforcement is close to impossible and incredibly difficult and incredibly time-consuming and just simply doesn't work with antiquated and outdated definitions that were written in 1956, and that they go hand in hand. And so looking at what all the folks have come to the table with in their concerns over what has been drafted in the past is not just the control over who picks, as you said, who lives in a particular house, or it's up to the landlord. That was the biggest issue, but it wasn't the only issue. There were a number of issues. Tying it to a lease, that was a big issue. That's now gone as well. The CUP again, or variance, that is now gone as well. The number of people per room, I mean, all the things that were tied into either threats of litigation, major concern from our housing department, who weighed in on this heavily prior to on the first draft as well. Those were the concerns. And so it's always boiled down to definitions and being brought up to what every other city for the most part is doing and what the best cases cited and the courts are, and making sure that we comply with fair housing. So we'll do a deep dive into that as well, but if you can just go on.
Yeah, just also on part two, this idea of definitions, when we are recognizing that by recommending a change from this sort of wide open definition to something that is, we believe in the mainstream, that it may cloud existing shared housing opportunities that exist currently in the city, right? So what we heard from council members, committee members throughout this is we want to make sure we protect legitimate small-scale opportunities to share housing. We don't want to inadvertently create a situation where somebody who's just renting a room to make the ends meet or would be impacted by a change that would introduce these new factors. So we were proactive. We heard that from committee members, and we wanted to make that perfectly clear. And so we included that in the definition of boarding house and dwelling unit. This notion that if you are renting 1 or 2 bedrooms out, and we capped the limit at 2 rooms for rent, you would be protected. You would not be a boarding house. You would be protected within this definition of a dwelling unit and a family. You would, if there's any question, are you a family? Is this room for rent back here? Are they part of your interactive circle or not? We don't necessarily want, it's a difficult call to make for our inspectors. So we wanted to also make sure that to draw a bright line at 3, where you don't really have to, an inspector doesn't have to make a call whether that first or second bedroom, whether they're meeting this definition of single housekeeping unit, that would be permitted regardless, and to actually recognize that within our zoning definitions. And so that is a change. That's also something we found in the mainstream of California cities, this idea of drawing a line at 3 rooms for rent, kicking you into a boarding house. That does seem to be the most common standard used, the cities that we looked at. It's something that the Attorney General has opined on and found to be legal. But we, again, wanted to reflect what we heard from committee members, or make sure we protect legitimate small-scale shared housing opportunities. So that is reflected in these new definitions. That is not in the previous versions as well. So that essentially is wrapping up the part 2 of the definition changes. Part 3 is we're calling more of an optional. We had some time to think about this, and is there anything else that we're missing with the problems that we've heard from neighborhoods about nuisances? We heard a variety of complaints about facilities that are deemed to be problematic, that are running up nuisances. We felt like most of those nuisances that we heard about are actually already covered. They're already covered by our zoning code. They're already covered by our building code. Things like noise, littering, loitering, overcrowding, et cetera. One thing we said actually is not covered is parking, and it's something we heard a lot about. Obviously, large-scale shared housing does have a greater propensity to have more cars and have a disruption and impact on neighborhoods. And we said that's something where our code is sort of silent on. Is there anything cities have done about this issue? Again, where they're really sort of egregious cases, you have many cars, many adults. Is there something that cities have done? We found that some cities in California have addressed this issue. It's actually mostly college towns. I think it started in San Luis Obispo and Oceanside, but San Diego picked it up a number of years ago, and they call it a residential high occupancy permit, or an RHOP. The basic premise is that any unit that has more than 7 adults would be subject to a sort of a check to see do you have enough parking and a process to mitigate parking impacts where they exist. The idea that we're proposing is that this would not apply if you don't have a car, if you don't have a driver's license. You would not be providing the extra parking for that person. There would be a way to sort of certify that. But for basically, if you have 7 adults with 7 vehicles, you would begin to add an extra parking increment on top of that. And that parking increment, what that would be is certainly up for discussion. San Diego has a much higher threshold of 1 parking space per person minus 1. So they say if you have 7, 8 people, you would need 6 or 7 spaces. We felt that was a high standard and might not be able to be met in a majority of cases. And I think the idea here is to mitigate parking, not necessarily to create uses that just can't find very many viable places to exist. So we're recommending a threshold of 0.4 parking spaces over the 7th person. So when you have 8 or 9 drivers with cars, you would be expected to then provide 0.4 correction. So 8 or 9 three-car spaces on site, 9 or 10 4-car spaces on site, and kind of keep going with the 0.4 ratio after that. Like I said, we're proposing an exemption like San Diego has for people that don't have vehicles. They would essentially sign under perjury that we don't have vehicles. We only have this many vehicles, and we would not count them as an adult for the purpose of this code section. That's essentially it. And again, there's a lot of questions. This is a rather new idea. We haven't had probably as much time as we'd like to sort of vet it and answer all the questions with our departments. I know there are questions with the other departments on this issue. But we wanted to see if there's any interest in further exploring this issue, and we'd be happy to come back on it.
Great. I would like the opportunity for colleagues to ask some questions. I want to recognize, though, the fire department here as well. And I don't know if we'll have the opportunity yet today to go through that, but one of the components that's been discussed in the past and looking at their care facility instruction and what the fire department does for inspections for safety on assisted living, residential care facilities, adult residential facilities, congregate living, group homes, residential facilities with chronically ill, congregate living health facilities, social rehabilitation, halfway houses, community correction, reentry centers, community treatment programs, work furlough programs, alcoholism and drug recovery or treatment facilities are all inspected currently by the fire department. And they're done so, or should be, and can be, under the code. It's allowed. And looking through their guidelines, that's what we'll go through in terms of what the state allows. And those are on licensed facilities only. So those that are not licensed, that fall into those categories, that are operating those types of facilities, sort of fall into that issue of non-inspection as well. And so we'll figure out where that falls in once we get through probably this portion of it. So with that, I'd like to open it up to my colleagues.
Is the housing department here? Yeah, I'd like to have the housing department come up, if I would, Mr. Chair, because the housing department, I think, put together succinctly some concerns with the draft ordinance and with the report, and I was hoping that you could walk us through what those issues are.
Were those submitted to the committee?
No, they were not.
I have not seen that.
I have extra copies of that for you all. I only brought 4 copies. Good morning, council members. My name is Claudia Monterrosa, and I'm the director for the Public Policy and Research Unit at the Housing and Community Investment Department. We really want to acknowledge and commend the work of the Department of City Planning in really bringing forward a report that has thought about the issues about fair housing and privacy rights and other concerns that have been raised over the years. We do think that, however, there are still very much lingering concerns, significant concerns still, given the changing of the definition. So, our concerns are revising the creating divisions which impact the determination of family, not only pose potential issues as it relates to people's rights to privacy and fair housing laws, but also calls into question the proper mechanisms the city is to employ to carry out the verification of what a family unit is. If a household is deemed to not satisfy the proposed family criteria, what happens to those occupants? Who is responsible for relocation of those residents? Changing the definition of family through the creation of single housekeeping unit fails to address complaints regarding nuisance issues in residential neighborhoods, which is at the core of the issue that we've been dealing here for a very long time. Instead, the proposed definition potentially limits housing choices for various protected classes of people, persons with disabilities, familial status, race, etc. enforcement of the single housekeeping unit potentially raises privacy concerns. Authorizing city inspectors to make family determinations by asking very personal and inappropriate questions about the household relationship among residents can affect people's lives and have a disparate impact on protected classes such as people with disabilities or people of color. We do recognize that the changes in dwelling unit and boarding and room house is a step in the right direction, but those two definitions really do hinge on the change of the single housekeeping unit. And in the past, as the planning department explained, the city engaged in a very long process to change the definition of family in 2006. That has not taken place during this time. So we have had a discussion about family around the community care facilities ordinance, but not around what the change in family will do in and of itself. So that's something that hasn't been properly vetted or has been paid the attention that it was paid the last time around to make it current. So it is open, and it was something that was approved jointly by both the planning department, by the housing department, and there was a working group, and I believe that, and we believe that that is due and is necessary for this particular change. So at this point, the Housing Department respectfully recommends that the ad hoc committee do not approve the recommendations contained in the DC report given the potential liabilities the city may face as currently drafted both at the front end and at the back end of things. Instead, the proposed ordinance should remain solely focused in bringing the LA Municipal Code into conformance with the Community Care Facilities Act of 1973. We recommend that instead of changing the definition of family, that the City Council revisit the nuisance abatement process. The city's nuisance abatement ordinance should be evaluated to determine how it can be used to address nuisance properties as voiced both by council and residents through the public hearing process. The city should rely on existing tools rather than creating new programs and policies that will further strain already limited city resources. In the event the City Council decides to further consider this issue, we recommend that the City Attorney review and determine the legal ramifications of the proposed ordinance as it pertains to fair housing and privacy laws. We recommend that an expert in fair housing law be assigned to review the proposed ordinance. Additionally, the criminal branch of the City Attorney should review the proposed ordinance as to enforceability of the provisions outlined. How will a single housekeeping unit or boarding or rooming house be enforced and by whom? Thank you.
You know, you said something that I think really encapsulates sort of my chief concern about the sort of the potential for changing the definitions, and that's the enforceability of dealing with code enforcement issues and sort of the complaints, the reason why we're here. Your department primarily handles multifamily situations?
That's correct. Anything that's 2 units or more.
And so understanding that there are, you know, the excessive sort of noise, smoking, some of the things that are alluded to as problems, how do you deal with them in a multifamily setting? What is it that you all do to be able to remediate sort of those issues?
For that, I would like to bring up our Chief Inspector, Daniel Gomez, so that he can help assist in answering those questions.
And I think sort of what would be helpful, too, is to understand what kind of interplay, if any, there is between the Department of Building and Safety and Housing, and what sort of tools are in our sort of arsenal to be able to dispatch folks to deal with these issues.
Good morning, honorable council members. Daniel Gomez. The responsibility of Housing and Community Investment Department is limited to inspecting the existing buildings for habitability and conformity with the essentials of life, fire safety, and structural safety. When it comes to noise and nuisance conditions, that's not within the scope of our regulations. We can handle litter and trash and debris, but sound, we must refer to building and safety when it's equipment, and when it is noise caused by residents, that is something that goes to the police department.
So primarily health, human safety sort of inspections, habitability, I always have a problem with that word, making sure that units are habitable, but in terms of sort of dealing with nuisance abatement and that sort of thing, you partner with building and safety and police if you have to.
Correct. It's a partnership with all city departments. When it comes to nuisance abatement, as priorly discussed here, we do not do nuisance abatement in the way that the zoning code describes it. What we classify as a nuisance might be a substandard building, for example, and we'll issue an order to correct it. But the nuisance abatement process that was mentioned earlier exists in the zoning code, where you gather evidence and essentially strip the building of its right to be used, which we do not do.
Very good. And you only deal with multifamily sort of dwellings?
Multifamily, beginning with 2 rental units on a property.
How do you deal with issues where you have 7 or more people in units?
Presently, we do not regulate the number of occupants, and it's never been the will of your predecessors on City Council to do so, and we do not count heads or bunk beds or anything like that.
Very good. The reason I asked that, Mr. Chair, is that I think, at the root of all of this is trying to understand how to enforce our existing sort of codes. And I think my biggest concern and fear is that if we change the definitions, that the mechanism to try to root out some of the challenges that we see in areas could displace housing opportunities for people. And I think ultimately what we should be doing is abating the issue, not so much the type of sort of residency and housing, because I'm afraid that the unintended consequence there is going to really limit the supply of housing for folks. And so I absolutely appreciate the fact that the committee, the council, yourself has been at this for well over 10 years, but it's beginning to feel, to me at least, that there's a sort of square peg and a round hole here. I ask those questions of HCID because, to me, the commonality here is trying to figure out how to be more proactive in the code enforcement from my perspective, because you could have units that are overly crowded and units that have the same sort of issues and concerns, and arguably more sort of concentrated because they're multifamily sort of situations. And if we can deal with those situations there, then we should be able to deal with them in a single-family residential environment, is my thinking. So I absolutely commend the work that's been done, and certainly along Part 1, I think, to me, that's the part that ought to move, provided that we have the opportunity to sort of have people, stakeholders, review that process. But I got to tell you, I really do think that Part 2 should go to the Housing Committee to see how it is that it's going to interplay potentially with what I think our chief goal and objective is in that committee, which is to make sure that we have as much housing stock available. And my concern from a land use perspective is that we're going to start sort of picking areas where these opportunities will fail or succeed, and I'm not sure that's something that we want to see happen.
Great. Mr. Bonin?
Thank you, Mr. Chair. I've got several thoughts. One, just in terms of the breakdown of 1, 2, and 3, I'm generally supportive of Section 1 and would be supportive of moving that forward, provided that before the ordinance goes to council, we get a little bit more feedback from the licensed facilities. I want to say something, though, about the process and the issue. I agree with almost everything. I agree with everything Mr. Fuentes said, and I share his concerns, and it's the reason I'm on this committee. We've talked a lot about how that we want to weed out the bad operators and protect the good, and that was my intention in getting here, in being here. But it has become clear that there is a problem with a conflict of some of our definitions. I'm very wary of addressing some of these redefinitions, but I think it's become clear that we need to figure out a way to do it. Because if you read some laws, it says this is permissible. If you read other ordinances, it says it's not. And that's not fair to the operators, it's not fair to the neighborhoods, it's not fair to the policymakers, and it's not fair to the enforcement agencies. I want to say to housing and to the Inner City Law Center, I think both of you need to do more. Even though I agree with your concerns, I think you both need to do more to help us get to a solution. Housing. It was not cool that this got dropped on Mr. Englander, the chair of this committee, in the middle of this meeting. That's not cool at all. This is an undated letter, an unsigned letter. I think I agree with every word in here, but the process isn't cool, and that's not how we should be going about it. I think we all need HCID to not just say no to this policy that's proposed, but to help us get to a yes.
If I may say something to address that, Mr.
No, let me finish, please. Inner City Law Center, the same thing. I'm with you guys totally. Given more time, perhaps the next committee meeting, there's a lot of these questions that you've posed in your letter from this morning that I want to ask. But I think it's also clear that just enforcement isn't the only thing we need, because I think we all know that the city is never going to have all the enforcement tools that we need, and some of the problems with the definitions are problematic. So I don't like some of the definitions. I'm afraid of Gladys Kravitz peeking in people's windows and trying to decide if they're sharing meals together or whether or not people are sufficiently washing the dishes or mowing the lawn and stuff like that. But we need some help figuring out what right definitions would be. Because it's not cool that we have a definition of boarding house that conflicts with family, and then you throw into all of this, the increasing dynamic of Airbnb, and stuff like that, and it gets very confusing and very messy. So, Mr. Chair, I don't know if you want me to ask questions. We've only got 5 minutes left. I've got probably a half hour.
This is what I'm going to do, because I want Mr. Price to weigh in on this as well. This is what I'm going to do. It's not agendized for public comment. We have a number of cards and a lot of questions and a lot of concerns. The next committee meeting, we are going to start at 8 a.m. We can either, and I'll take a poll here of my colleagues. We'll either start at 8 a.m. or we'll do it after council, so we have an entire afternoon and we're not rushed out. I want to hear all the public comment, all the public testimony, and spend a good quality of time on that. I'm also going to ask the city attorney's office to respond to housing letter. I do appreciate that you brought this up. As Mr. Fuentes clearly walked in with a copy of the letter before it was distributed, it would have been nice to have the chair also get a copy prior to the meeting and have a discussion or a meeting with my office. I've always said I'm available at any time. I agree and I appreciate Mr. Bonin's remarks. It's always been a no, but I think we'll respond to it and have our city attorneys, as Mr. Fuentes said. In terms of, so I want to let you know where we're going in that direction.
And when this comes back, I would like more information from staff on, as we talk about defining single housekeeping unit and family, I need a definition of what interactive is. I need a definition of what non-transient is. And I need a sense of who's going to monitor that. Who is going to be able to say that this household is sharing resources and this isn't. There's a number of questions the Inner City Law Center has asked that I want to repeat, and I'd be happy to send those in a letter from me to the department, because I'd like to ask very specific questions about what the impact would be on a New Directions facility or a Venice Community Housing facility, because that speaks to the concern that Mr. Fuentes raised. We can't make it harder for people to be living together in a mutually supportive environment, and I'm afraid that some of this could do damage to those people, and I want that addressed when we come back.
Thank you, Mr. Chairman. I too want to just thank you for your efforts, your ongoing efforts to bring some clarity to an issue that impacts the whole city. And appreciate the report that we've heard, but I too want to just associate myself with my colleagues' concerns raised by the colleagues that changes in policy like this are going to dramatically impact the availability of housing, certain kinds of housing that are of a real importance in the community that I represent. And I think we just need to have a full discussion of what these definitions are. We certainly have heard that over the years, many have been at the table as the definitions have been crafted. And while this was done a little more hasty, I think there certainly is an opportunity to have more input in the process. I think we need to have housing at the table. We have to have the city attorney at the table, and stakeholders as well. And so I'm anxious that we're pleased, I should say, that we're going to continue the discussions. I think is what you're saying today. and an opportunity for a much more detailed, in-depth review of the recommendations. And again, I think we want to see how we can make this work, not how we can eliminate stuff, but how we can be as inclusive and as supportive as we can, especially to communities in need and individuals who are, struggling with the basics. Frequently, these kinds of housing issues address that. And so I'm anxious for the discussion to continue. Mr. Chairman, I hope that we will continue to cast as wide a net as possible. And I agree that, no excuse for us not having, some information that basically pans the report of the recommendation. It'd be nice to have that in advance and appreciate your leadership in making sure it doesn't happen again.
Thank you very much. With that, here's what we're going to do. First of all, if we could get an update on those particular definitions that Mr. Bonin asked for to be submitted for the next meeting. We will schedule an after council, so we're not even with the 2-hour at 8 o'clock. We'll do it either an after council meeting or we'll do it on a Monday or a Thursday. And I'll check with scheduling and see what works. Giving people plenty of information and notice as well. It's not going to be a rush special meeting. You'll have notification. I want to make sure people have the opportunity to speak. With that, we're not going to send anything to any other committee right now, because if I did, and thinking about that, it would end up going, quite frankly, not just to housing, but we could send it to LAPD, to the commission. We could also send it to public safety. We can send it to the fire department commission. We can send it to public safety relating to the fire department matters. We can certainly send it back to planning. We could send it to housing. We can send it to the committee as well, or the commission, or both. That's why we formed an ad hoc, to bring all those folks together. And what I'd like to do for future meetings is we'll ensure that we have ample time for the departments to address this. I would like to also instruct the city attorney to review housing's last-minute letter and address those concerns and recommendations that were brought forth. And we'll make sure that we answer those. And from the city attorney and the planning department to work together for answers on that, and that'll come back and we'll discuss that and do a deeper dive. I agree with everything all of my colleagues have said, including Mr. Fuentes, Mr. Bonin, and Mr. Price. We've got to be very, very careful and quite frankly, the concerns that you brought up in your letter from the housing department are all valid concerns. They have to be addressed. We've said it from day one. That's the purpose of this. But there's no solution there at all. And the issues that were always brought up in the past and addressed, this committee eliminated 99% of those. And that was not acknowledged either. So we'll make sure that we address these as well. With that, I'm going to give an option to those that filled out speaker cards and are here. It's the same group of folks. I don't see any names that haven't been here before, and I would anticipate that you would be, and given plenty of time to really get in depth on the record as well. I will ask this, if anybody wants to submit documents for this committee for review, please get it in, if you could, before a committee starts, if you've got written documents that you'd like us to look through and answer and research and post perhaps on council file as well, and indicate that so we can keep a log. I'll give the opportunity for a minute of public comment on each of these, or if you'd like to hold off, if you submit a card today and would like to hold off, I'll give you even more time than normally on the next meeting, so we can actually have a real discussion, take an afternoon, go through and roundtable this, and we can do a deeper dive, because I think we're at the point now, which is a great thing. This is where we hope to get to, where we start looking at proposals and real definitions, start seeing the real world applications to that, and get input from both our experts in-house, planning department, housing, city attorney's office, building and safety, the fire department, all of those that have to deal with this each and every day, and to make sure that it's applied fairly and equally and legally. And then those providers out there as well, which are many of you and the community and the stakeholders and residents. So with that, I'll just ask by name if you want to come up, or if not, we can hold your card for the next meeting and do as I suggested. Greg Spiegel? Sure. I won't put 20 seconds on the clock, but...
I just want to say that we're willing to work on everything and anything, and we want solutions. But I also do want to say that this process has not always been open to people who aren't at the table here or directly invited. We have 1 or 2 minutes for public comment, and there's been a lot of talk about stakeholder panels would be a part of this. We've come all this way. You guys could have voted and approved this today, and we have never been a part of a stakeholder panel. Only certain agencies have come up. This is the first time I've heard from the housing department, so it hasn't really always been an open process, and that we would love for that to change going forward. So we would love to know that before a decision is going to be made, everybody who's affected could really be heard from and contribute fully, and not just in public comment. Thanks.
Great, excellent, thank you. Ryan? Involved? Okay, thank you. Paul?
More time later, please.
You got it, Paul, thanks. Peggy?
All right, thank you.
Okay, thank you. Leslie?
I would like to wait.
Oh, there's two Leslie. Leslie Clark.
I'll wait.
Okay, thank you. Fernando?
I'd like more time.
Yeah, you got it. Jason?
I'll wait.
Autumn?
I can have the 20 seconds.
Well, you take more than 20 seconds, but yeah.
Sure. There was a lot in the report, and we didn't have a lot of time to process it
Right.
or to draft comments, which I think explains why you didn't get written comments to the extent you got them until today. So to the extent that there are kind of these major sea changes and shifts and all of that, if they can be shared with the public well in advance of the public hearing, that would also facilitate an open
Well
discussion.
noted. I appreciate that. We'll make sure that happens. Thank you for that. I called, did I say Fernando? Yes. Steve? Yes. Okay, thanks. Wesley? Walker?
I would like to wait my time for next time.
There's Wesley. Yeah, all right. You stood up earlier. Thank you. Wesley Walker. That's a cool name. Sounds like a movie star, Wesley Walker. And, yeah. And, of course, Herman. He can start his clock.
I did sign the card as Jack. However, we see that LA Municipal Codes violations continue against people who are homeless, against this so-called process of what ad hoc transparency when nuisance in neighborhoods. My mother left this neighborhood because she got tired of all the nuisance the city has created, and she moved out. And now I, a homeless person created by the city of Los Angeles, and a homeless person is going to move and live in Mr. Bond's neighborhood in my car whenever I want, and how it makes me feel comfortable. And maybe in Mr. Fuentes' area I'll go live. But the point of this, and this criticism, and it's the truth, I am a homeless person created by the city of Los Angeles, is this. We deserve more action by this ad hoc committee to participate fully with the public. Public interest should always be the main concern. So if there's no transparency and you're not going to take the time to listen to us, this is a joke. Keep up with the state license, and remember American Disability Act.
So, just so you all know as well, what I've done is I've taken your cards. You won't have to fill out another card if you're here for the next meeting. We're going to resubmit those as well. That's normally not the case, but I want to make sure that I call you up again if you're here, and we'll give you that opportunity. This will also give us a little more time for you to all digest what's been put out there. I think what you've heard in the discussion as well, it's a big issue. We've been dealing with this a long, long time, and we absolutely, and I want to thank my colleagues, want to apply this as equally and fairly as possible. And I really want to thank the Planning Department. They've done an incredible amount of work and research on this as well. And we are adjourned. Thank you.